Mr. Knowles.
May it please your lordships and my lady, I'd like to begin, if I may please, with a synopsis of how I say the law got to where it is now, and then I will sketch out my submissions more broadly and then move into the detail. I have 2.5 hours on the timetable.
Yes, you do.
I anticipate, I'll do the best I can, but being 2 hours this afternoon on joint enterprise more broadly, and then half an hour in the morning on the specific submissions on which we were granted leave to appeal on behalf of Mr. Ruddock. As your lordships and my lady will have seen, we were granted leave to appeal on 2 issues. One, the judge's direction on joint enterprise, which we say even on orthodox principles was wrong, and secondly on a piece of hearsay. And so we don't lose sight on it. You also gave us leave on sentence, which isn't opposed because there was a backdating issue. So how we got to where we are now in my submission. We say the following steps can be traced in the evolution of the law. Until 1985 and the decision in Chan, secondary liability in English law was based upon, firstly, basic accessorial liability, aiding, abetting, counselling and procuring, and 2, common purpose, which is a subspecies of basic accessory liability. Step 2, what was contemplated, we say, was regarded as evidence of the scope of what had been agreed, the scope of the common purpose, but was not treated as defining it. And we say that is the proper reading of Wesley Smith and Anderson and Morris, and the case of Reed in 1976. We say those are all cases of common purpose with the Act either falling inside or outside the common purpose, but they are not cases properly read where foresight is introduced as actually delineating as a matter of law the common purpose.
Wesley Smith, Anderson and Morris and?
Reed.
Oh, yes.
The 1976 decision.
Yep. When you say common purpose is a subset of basic, does it operate in this way? It can, without distorting basic principles, in some cases enlarge and in other cases arguably retract the operation of basic liability in this sense that there may be a conditional intent, a consensus that if this arises, we'll do this.
Yes.
And that would, as well, therefore extend the potential liability beyond the primary purpose.
Yes.
But simultaneously, it fits within basic accessorial liability because the limits to basic accessorial liability are sketched out in part by the scope of the encouragement, etc.
Yes.
Those cases cited in Hale and
Yes.
Foster about 3 highwaymen, etc.
Yes.
So it's not a separate doctrine.
No.
It fits within the basic accessorial liability principles.
Yes.
That may, in some cases, enable the prosecution to put a more advanced case. In other cases, it enabled the defence to put a more attractive case.
In the days when it made more of a difference also, it allowed everybody to be treated as principals rather than as secondary parties before we had the 19th century statute. But yes, your lordship is quite right. It's a subset rather than a separate liability. Can I just say, and I think your lordships have this point, although there's a suggestion on behalf of the respondents that what we are calling parasitic accessorial liability can be traced back to the ancient writers, or we say that's not a correct reading. The law spoke in a very different language in Plowden's day. Foresight and intention didn't have the meanings that we ascribe to them today. As I think Dr. Dyson says, the law was painted in broader brushstrokes than it is today. So we say, and as I'll explain, that parasitic accessorial liability is really an invention of quite recent times. So it is right that in 1957, and this is the third step, in 1957, the word in Davis, the word contemplated was indeed used by Lord Simons. But as your lordships observed this morning, and I'd respectfully agree, it was a throwaway line in a case that wasn't about joint enterprise at all in the sense we're describing it. And it certainly wasn't a considered principle.
Yeah.
We say the seminal step, or the most important step, pre-PAL certainly, was Chan in 1985. And we say that did 2 things. It laid the basis for contemplation as the test of liability, although as we've seen, Lord Cook, as he became, also used authorisation on one view, treating them as synonyms, contemplation authorisation for my purposes. But it treated that as delineating the scope of a common purpose. In other words, it turned what had been a rule of evidence into a rule of law. It did so, and this is step 5, on the basis of Johns, the Australian case. As Lord Cook observed, there'd been little English discussion or authority on the principle, and so he turned to common law authorities from other jurisdictions. There are, however, a number of points about Johns, which I will return to, but can I sketch them now? As Dr. Dyson notes, or noted in his work that was incorporated into the Jogee Foundations, in Australia, Australian common law, foresight of probability of death is sufficient mens rea for murder. 3 out of the 9 Australian states have codes, but where the common law applies, foresight of probability of death is sufficient. So in Australia, it is less odd that a secondary party can be liable on some sort of foresight basis when that's sufficient for a principle. The disconnect that we say exists in English law, where a secondary party can be guilty on the basis of foresight, where a principle needs intention, we say is a much more stark deviation than in Australia, where foresight is much more in play. That leads to my second point. It could be, and I'm speculating, but that could be the reason that some sort of foresight on the part of the secondary party seems to have been accepted by everybody in Johns. That wasn't the point that was in play. It was, is it probability or is it possibility, and other issues. But it certainly seems to have been taken as a given, without any argument, that some sort of foresight was sufficient.
The question is whether it was of evidential significance or whether it constituted the supply of a requirement of substantive law.
Yeah.
Well, it seems to have been treated as a matter of substantive law, doesn't it?
It seems to be, yes.
But as you say, the issue was probability stroke possibility, rather than whether foresight was the wrong test altogether.
That's right.
You can get a little bit more if one actually looks at the judgment of the New South Wales Court of Appeal,
Yes.
which isn't actually in the bundle.
We can supply it, I noted that. Yeah.
It's 1978 1 New South Wales Law Reports. And one can then, when you read the judgment of the majority, link it in very clearly with the judgment of Chief Justice Street in the Court of Appeal.
That's right. But my point in the synopsis is when one is looking at Johns, which does seem to have heavily influenced the decision in Chan, which has obviously had the impact, one does need to actually look at it, and it is striking to note that the principle was just assumed in Johns for reasons, as I've said, we can only speculate about, but it may be that there is a difference in the Australian common law. The next point about Johns, and this is a point Lord Toulson recognised this morning, Johns was a case of shared intent on the part of the principal and the secondary party. The injustice that we say PAL works in English law is that it's foresight on the secondary party alone, which is sufficient. And the other point about Johns, and one needs to look at the facts to get this, Johns on one analysis is just an ordinary common purpose case. The facts in Johns, just very briefly, when Mr. Johns was the driver, who, when interviewed by the police, said that his mate had said, "I'm not going to stand any nonsense," and it showed him the gun, which was indeed used. So on one view, Johns is just a plain vanilla common purpose case where two men embark on a criminal enterprise, and one says to the other, "I'm not going to stand for any nonsense here, I've got a gun," and the other person continues with him. It certainly is factually not the typical sort of case on which PAL.
Are you intending to be going to Johns as you?
Yes, I'm just giving you a synopsis.
Yep.
At the moment, my lord. So the next stage, that was Chan Wing Sui in 1985. Then we have the Chan principle after the false start in Wakely that we've seen. Then we have the Chan principle applied in England by Lord Lane, as he then was in Hyde and Slack and other cases. And then came Hui Chi Ming, and we say that did two things, at least two things. It read contemplation as indeed equivalent to authorisation. And it made clear, as your lordships noted this morning, that foresight on behalf of the secondary party alone is sufficient, whereas Johns, it had been both the principal and the secondary party. And then last, in the synopsis at least, is Powell and Daniels, of course, in 1997. The majority, treating Lord Mustill as having gone on his own path, but the majority certainly said that foresight was enough, basing themselves on Anderson and Wesley Smith. And what Lord Hutton said was a strong line of authority with respect, I will disagree with that proposition, because on our reading of Wesley Smith and Anderson, they're not cases about foresight at all. But rightly or wrongly, we say wrongly, in Powell and Daniels, foresight was established as the test, and that was the term which Lord Hutton positively encouraged judges to direct juries in terms of, rather than tacit authorisation or anything else. It rejected the argument based on intention. It's right to say, and I say this as junior counsel for Mr. English in that case, the way the intention argument was framed in Powell and Daniels was by reference to Maloney and Hancock and Shankland. It was very much, well, if you need intention for the principal, you must need intention for the secondary party. It wasn't put in the way that I'm going to put it, that if we look at the roots of the jurisprudence, it's intention in the common purpose sense. And that's the magnet, if you like, that should pull us back to some sort of intention-based test on behalf of the secondary party, rather than by reference to Hancock and Maloney. But that was the basis on which it was argued, but those arguments were rejected. And the third thing that Powell and Daniels did, that I don't think we need consider in this case, is of course, it introduced the fundamentally different Act test. In your Lordship posed the question this morning by reference to the example you gave in Rahman, that if the secondary party intends grievous bodily harm, on what basis, but death occurs, on what basis might he escape liability? Well, that was in fact the situation in Mr. English's case, as you recall. They beat the officer with pieces of wood. Mr. English was chased off, and at that point, Weddell, his co-defendant, produced a knife and stabbed the police officer fatally. The judge had directed the jury, well, if you determine that foresight of GBH using sticks was present, if you're sure that was there, then that carried over to the actual killing. But that was what gave rise to the fundamentally different test. But to answer your Lordship's question, on what basis could you escape liability, it would be if it's a fundamentally different act. So, my Lords, that's what we say. That's we say the story and how the law got to where it is today. And we say there are two principal errors in that synopsis. One was the elevation of the principle of evidence to a rule of law. And secondly, we say that Anderson and Morris and Wesley Smith were misinterpreted in Powell and Daniels as being authority supporting a foresight-based approach. So coming then to my summary of submissions in what I'll be developing this afternoon, we say that the current law of joint enterprise, and I'll be speaking to our accessorial notes that we submitted back in June. We say the current law of joint enterprise based on foresight has little relation to the classic modes of secondary liability. And we say that it does represent a significant and unjustified departure from historical jurisprudence. This has resulted, we say, in an exceptionally low form of mens rea, foresight of risk, which stands apart from the mens rea which the common law typically requires. It is, on any view, a very low form of mens rea. My learned friend said only strict liability was low. It certainly is very low. Foresight of risk is a low threshold. Your Lordships, in granting us leave, invited submissions on the foundations of secondary liability. And we say that when the sources of the current rule are properly analysed, there actually is, as I foreshadowed in my synopsis, only a slender foundation. We say that Anderson and Morris and Wesley Smith, which featured largely in Powell and Daniels, are really about common purpose in its traditionally understood form, i.e. agreed conduct plus perhaps unforeseen consequences. My learned friend and I agree to assault somebody and the person has a thin skull and die. We're liable for manslaughter, even though that was an unforeseen consequence if we've jointly agreed an assault. But we say Anderson and Morris and Wesley Smith are really about common purpose, with references in those cases to tacit agreement, meaning just that, agreement. We say that they were misinterpreted in Powell as authorities supporting the foresight test in parasitic accessorial liability. And we say, and I think with respect, in agreement with my Lord Toulson in one of your extrajudicial writings, which I'll show in a moment, we say that Powell and Daniels did introduce a new principle of English law. True it is, it built on Chan, but it reaffirmed as part of the English common law that which had been established in Chan. It was a new departure from the law as had been historically applied and understood.
You may or may not want to cover this, but I think that Anderson Morris gets rather differently interpreted in Reed from the way in which it was interpreted in Parliament English.
It was.
The irony being that in Reed, it was Geoffrey Lawrence, QC, now Lord Justice Lawrence, who was part of the court that put one sort of interpretation on Anderson and Morris.
Yes.
Whereas in Parliament English, although one can see the case was cited in argument,
It was, yes.
none of their lordships felt it necessary to make any reference to the case.
No, indeed, and that's a point your lordship made in your Glanville-Williams essay.
Oh, did I?
Yes.
Well, I apologise for repeating myself.
Not at all. It may save me the need to go to it, but that is a point that you made in the Glanville-Williams essay, that Reed was cited. It was a strong court of appeal, as you observed this morning, and it did place a different interpretation on Anderson and Morris, and one that was contrary to the interpretation Lord Hutton placed on it. And that is one of the reasons we say that Powell was in error on this point.
I think they probably... I think Mr. Scrivener appeared for the prosecution in Alan Morris and
He did.
swept it aside on the basis that everything was said in Reed was obiter.
Yes, I think that's probably right. It could be, and we're speculating because, of course, Lord Mustill, although he prepared a speech, didn't deliver it, he just gave a sketch, but he referred to his understanding of the law hitherto as being that it was the test was common purpose and intent, and it could be that he was reading Anderson and Morris and Wesley Smith in the same way that your lordship did in your Glanville-Williams speech. In other words, as not establishing foresight, but as being cases about common purpose involving or needing intention. And we say the second wrong, so that's the first wrong turning, or that's the first error in the law, is Powell and Daniels and how it read the earlier cases. We say the second error is Hui Chi Ming treating authorization as a synonym for contemplation. We say, and I'll be taking you to some academic writings on this, but the starting point is we say authorization, even on its ordinary meaning, has a very different meaning to contemplation, and I probably don't need to elaborate upon that. Authorization is much closer to agreements than contemplation. One can contemplate something without wishing it to happen, whereas authorization connotes a desire, a wish.
Well, be careful about wish. Intent isn't entirely synonymous with wish, is it?
It's a more positive affirmation than mere contemplation.
I intend to go to Manchester, but I don't wish to go to Manchester.
Well,
It's always the illustration of that distinction.
It's
that
not planting
Mr.
bulb.
Brian Davenport QC used to trot out at the Law Commission.
I grew up in
planting
Manchester, so
bulb.
I could recommend.
Well, I spent 18 years of my life in Manchester, so...
Thank you. Yeah. But that's the second error we say. It's to read authorization as contemplation. Hui Chi Ming took a wrong turning because we say the two terms are different. And one of the solutions, just so your lordships know where I'm going, one of the solutions I'll be offering, we offer the Wilson and Ormerod formulation in our paper. But another solution, if your lordships are persuaded that the law's taken a wrong turning and a heightened form of mens rea is required as a matter of justice on behalf of the secondary party, would be to require a degree of authorization properly so called in the secondary party. Acknowledgement, acquiescence, encouragement, one of those states of mind. That represents a halfway house, perhaps, from where the law currently stands, requiring the low mens rea of foresight, halfway house between that and intention, which is strongly criticised by the respondents as being unprovable in practice as far as secondary parties are concerned. We offer authorization in some form as being somewhere on the scale between the two. That would exclude from liability for murder what we say is the classic injustice case of the secondary party who, because they're weak, or because they're frightened, or because they're mentally infirm, or for whatever reason, go along with a dominant figure, knowing that the dominant figure has a propensity to be violent, and knowing that that may well be a risk, but they don't want it to happen, they don't really want to play any part in it, but it happens anyway. We recognise that the rule in its current form, now as we stand today, has been the subject of consideration by senior courts on numerous occasions, obviously most recently in Ganango, although it was obiter there. But we do submit that the time has now come for your lordships to correct what we say were errors in the development of the common law. That the law is in need of correction is a widely held view. And I'll be taking you to some of the commentators. They don't all sing with one voice, as the respondents point out. The Law Commission, obviously, in 2007 didn't propose a change in the Chan-Win-Su principle, and we know certainly what the government's position historically has been on it. But nevertheless, we say there is a very wide range of judicial criticism and academic criticism. We say that the current test does risk injustice because of the disconnect between morally when somebody should be guilty of murder and what the law simply requires in terms of foresight.
When you talk about connect and disconnect, are you at any stage going to be saying anything about the statutory formulation of inchoate offences?
Yes, I will be coming to that. We say that the reason for what the disconnect reflects is a result that runs counter to the policy and moral objectives which ought to lie behind secondary liability, namely to recognise and appropriately, and the emphasis is on appropriate, punishment of a party who doesn't commit the core actus reus, but is nevertheless culpable in relation to it in a way which calls for condemnation and punishment. We say the erroneously expansive approach has brought about a situation where someone who's not in any ordinary sense culpable for murder, which is principally what we're concerned with, can nevertheless be convicted of it and therefore suffer the full consequences of the law. In short, we say the problem is that there is a very low form of mens rea, too low, and that the solution is to require a heightened form of mens rea. I've indicated the Wilson-Ormerod solution of intent and conditional intent. I've also indicated another possible solution would be to reintroduce authorization in the sense that word currently bears as a matter of ordinary language. Linked to the question of change is who should make it if your lordships are persuaded that the law is defective in the ways that I have indicated. And we do say that it is properly a matter for your lordships, and that this isn't a topic that lies exclusively within the purview of Parliament. The first point we make as to why it should be for your lordships, and is properly for your lordships, is that this doctrine is of comparatively recent invention, and it is an invention of the judiciary. It is a development of the common law. If this is correct, and we say that it is, then the remedy we seek can be appreciated to merely be a correction of the law in a manner that the common law can cater for and has regularly performed. We're not inviting judicial legislation in an area that is more appropriate or only appropriate for Parliament. If I need to, I can come to the reasoning of Professors Ormerod and White, page B880, Mr. Justice Kirby in Clayton at B32, both of which are authorities or discuss the proposition that it is properly a matter for your lordships. The judicial expressions, and I'm thinking of what my Lord Newberger said in Rahman, that this is properly a matter for Parliament if it's to be changed, was said in a context where the correctness of the principle was certainly not debated in the depth we're debating it today. And although those are relied on by the respondents,
we say you could say that when the court perhaps exercised its common law power to make the most dramatic change in the area of criminal law was by abolishing the defence of husbands in rape cases. And it did so on the basis that the courts had gone wrong in the application of the common law, and therefore it was on analysis an unsound common law rule.
Yes. Yes.
Ditto recklessness.
Yes, absolutely. What we are advocating, although it's portrayed forensically by the respondents as being an unduly bold step, but what we are advocating is, as I have said, simply a common law correction of a common law creation of comparatively recent invention 30 years ago, if one takes Chan as the starting point, as I invite. In short, we say these two cases before the Supreme Court and your Lordship's Board represent a significant opportunity for a proper and just basis for secondary liability to be re-established. So I can pass, and I will try not to repeat what my learned friend said this morning. Our written submissions on secondary liability very much were derived from the very helpful document that my learned friends prepared with Dr. Dyson earlier this year. I will have something different to say on some aspects of it. But as I've already indicated, Secondary liability has been part of the common law since about the 16th century, so far as we can tell. It was originally founded on either a causal connection between the assistance provided and the offence committed, not causation in the but-for sense, but very loosely under the influence of the secondary party. Or it had to be on the basis of an agreement between the parties as to the way in which they would act. These two modes of secondary participation remained part of the common law's approach until, as I've said, comparatively recently. The first form, which I will refer to as basic accessorial liability, became enshrined in the 1861 Accessories and Abettors Act.
Now, if one wants a snapshot of how the common law judges saw it at that time, there's a ruling of Chief Baron Pollock, a case called Skeet, which is not in the authorities. It was Chief Baron Pollock at the Surrey Assizes at Kingston, but it's of interest, A, because of the author, and B, because of the clarity with which he spoke, identifying what he then perceived. At a time, of course, when we had the felony murder rule.
Yes.
We've been referred to other cases like Pridmore and
Yep.
so on. Are there any of those other 19th century or earlier cases that you want to take us to?
I will be coming to some 19th century cases in a moment. They're set out in our paper,
Right.
which talk about deviations from the common purpose and then the need for there to be an intent on the part of the secondary party. Collison's one of them, but I'll come to those in a moment if I may. So that was the historical position and our starting point for the development of PAL, and I say it's only our starting point, to go over what I've already said, is Davis and the use of the word contemplation. That's tracked by Dr. Dyson as probably the first place in the cases that one sees contemplation being used in this context. Although, as I've said, on proper analysis, Davis really isn't much help on the topic, but it's right that contemplation was referred to as a possible sufficient state of mind. Basic accessorial liability accrues when S aids, abets, counsels or procures. This is obviously Hornbook law that we all know and understand. S, the secondary party, must perform an act that amounts to aiding, abetting, counselling or procuring. In the modern language, assisting or encouraging are the two epithets which are suitable, while at the same time intending to do so. That means intending to do the act. So in other words, I intend to give my learned friend a gun rather than just accidentally leaving it out. And so I need to actually physically intend the act. And I must also, more importantly, intend to assist him in the criminal enterprise that he's to undertake. As to that, I only need to know approximately what he's up to. I don't need to know which bank or which day he's going to rob. But that's basic accessorial liability. Despite the growth of PAL, parasitic liability, this category of liability remains distinct. As we set out in the paper, they can overlap, as all these categories do, but it remains a distinct form of liability in the law. Common purpose liability provides that perpetrators who execute a common plan are liable for all the acts done by each party to that plan, including unforeseen consequences arising from the execution of it. Every single act doesn't have to be agreed upon in order for liability to accrue, as long as what was done in furtherance of the common purpose. The paradigm case and the phrase that one sees in the case is resist at all hazards, the gamekeeper sort of scenario, poacher and gamekeeper sort of scenario. As is set out in the foundation documents, the common purpose rule has been now largely subsumed, although not entirely, by parasitic accessorial liability, which amounts to a refashioning and a significant extension of the principles, and introduce liability for acts that exceed the common purpose in the sense of acts which were agreed upon, because it now permits liability to attach to acts which were merely foreseen. Coming to the cases that Lord Toulton asked me about from the 19th century, these are set out in paragraph 19 of our document. Many of the 19th century common purpose cases expressly disavow and this is an important point, they expressly disavow criminal liability for acts which the secondary party did not intend, but which now might be caught by PAL, making S liable. Thus, the courts found or held that in the case of Hawkins, B 1551 electronically, S was not liable for a robbery where, quote, there was no common intent to steal the keeper's property. They went out with a common intent to kill game and perhaps to resist the keepers, but the whole intention of stealing property is confined to Williams alone. Another case, the case of Collison, electronically B 1511. S was not liable for assault and wounding unless, quote, when he and his companion went out with a common illegal purpose of committing the felony of stealing apples, they also entertained the common guilty purpose of resisting to death or with extreme violence any person who might endeavour to apprehend them. But if they only had the common purpose of stealing apples and the violence of the prisoner's companion was merely the result of the situation in which he found himself and proceeded from the impulse of the moment without any previous concert, the prisoner S will be entitled to an acquittal.
Well, yes, of course, that would also fail the foreseeability test, wouldn't it? That would also fail the foreseeability test.
Yes, that one might do, but the reliance I'm placing on it is it's in the language of intention. Mm. Another case, the case of Luck and others, electronically B 1644. In that case, S and others was poaching, and in the course of that poaching expedition, a gamekeeper was shot and killed. Defence counsel made submission that there was no case, unless it were held that the prisoners, being all present, were equally guilty. The learned judge said he didn't mean to so hold. The whole question was for the jury, who fired the fatal shot? If that man could be identified, he was undoubtedly guilty of manslaughter. Next, whether he could or could not be identified, the question of which of the men were participating in the very act. Suppose all agreed that a shot should be fired, but the particular man who fired it couldn't be identified, they'd all be equally guilty. If the jury cannot say who fired the shot, they should not convict any of the prisoners unless satisfied all of them were parties to the act.
Now, this, like the Skeet case I mentioned, this is a direction to the jury, isn't it?
Yes.
It's Justice Byles directing the jury.
Correct. And then finally, in this quartet of cases, Macklin, Murphy and others, which you have electronically B 1649, it's a principle of law that if several persons act together in pursuance of common intent, every act done in furtherance of such intent by each of them in law done by all. The act, however, must be done in pursuance of the common intent. Thus, if several were to intend and agree together to frighten, and one were to shoot him through the head, such an act would affect the individual only by whom it was done. Now, again, as Lord Hughes has said, that probably wouldn't be caught by PAL either, but the reliance I'm placing on it is the language of intent. So we say that based on both of these forms of liability, to trace it historically, by the 20th century, secondary liability, as it had since the 1500s or the earliest times of the writers on the common law, secondary liability was underpinned by a requirement of intent in its proper form on the part of the secondary party. What was required was either that S was a basic accessory in the way that I've explained, who intended to aid, abet, counsel or procure a crime, knowing its essential elements, or the secondary party was party to a common purpose and was taken to have intended or to have implicitly authorised in advance, tacitly agreed, the criminal acts performed in furtherance of achieving that common purpose.
What I'd like to think about is what is the proper basis in terms of mental state of mind for what you've termed the alternative or the second basis, the common purpose basis. What they're really talking about? Are they really talking about intent only, deriving it from the agreement, or are they talking about something different?
Well, the cases use. I think on the cases it's difficult to have a coherent principle because different language is used in different cases. Sometimes what agreement's spoken about, sometimes tacit agreement, sometimes intent. I would obviously say that what they're really talking about is intent, albeit conditional intent, possibly in some cases. Either
No,
we will...
sorry.
Forgive me.
Finished, please.
No, yes, either we will do this, we are going out and we're going to shoot the gamekeeper, or if he spots us, we'll shoot him.
I'm just wondering what agreement encompasses beyond shared intent. It may do. I'm just trying to grasp what it is.
Well, you certainly don't need to agree everything in advance, or all the acts.
No.
Is the agreement as to what is done, whereas intent is as to consequences? I mean,
Yes.
it is important to draw a distinction
Yes.
between, because you've done that in your formulation,
Yes.
that you don't have to intend every
No.
unforeseen consequence, but you do have to
Agree forms of action.
agree what you're going to do.
Yes, no, I think that is the distinction.
May also depend on what you mean by shared intent. I mean, if two people come out of a pub and both start attacking somebody who's outside, they may both have an intent of doing him a lot of harm. They may, in that sense, share an intent, but they may be acting each perfectly individually.
Yes.
Well, they're sharing the intent.
Well, it's common rather than shared.
Yeah, it's kind of...
Yes.
On a small housekeeping point, I'm sorry.
Yes.
When you referred to Macklin a moment ago, I think whoever industriously got the bundles together has put the wrong case in.
Oh, right.
Yes.
Forgive me.
It's certainly not at page 1649.
There's a Macklin there, but it's
the wrong one.
it's somebody in Macklin and it's a bankruptcy case.
Right.
Something I know.
So can we check that? So we'll obviously supply you with the right.
Yes.
I think it's one of the cases referred to in the argument in Morris and Anderson.
Yes. Well, we'll certainly supply you with the right case. So that's where we say the law stood, and we say that PAL, in introducing foresight, stands as a marked departure from those principles.
I think if you look at the contemporary sort of criminal textbooks in prior to the departure of the law in 1985, but if you look, for example, at the time of Morris and Anderson, they're almost all uniform as to the test, aren't they?
Yes. Yes. Yes, absolutely.
There is no real dispute.
No.
And it goes right back
Yes.
through some of the cases that you've disputed with.
Yes, no, absolutely.
And I think that, one therefore is on fairly firm foundation at that time as to what the law was.
No, absolutely. Yeah. And Lord Mustell made that very point in Powell. He said it was the formulation with which countless juries have been directed over the...
So I think, that is, essentially one doesn't really need to go back to all these old cases, because I think it would be interesting to hear what Mr. McGuinness says, that the law was clear at 1965.
No, thank you. I would certainly respectfully agree. I've perhaps over-laboured it simply because it is...
No, I'm just thinking of, give Mr. McGuinness the chance to say whether he agrees or not.
No, thank you.
Tomorrow.
Yeah, thank you very much. So we come then to parasitic accessorial liability and its development. There are shades of it in Pridmore, which you were taken to by my learned friend this morning. That's at B1715, where the judge said, if you think that although it was not arranged between them... Can I say, my lords, to save time and because you've been shown, I'm reading the quotations from my document. I will, of course, go to any case. And perhaps
Would you just faithfully been following your
No, thank you.
case?
No, thank you. But I'm not cheating.
Save when you've been interrupted.
So Pridmore, as we've set out in 1913, had language not a million miles away from parasitic accessorial liability. If you think that, although it was not arranged between them, the nature of the enterprise was such that both must have realised that resistance at all costs was likely to happen. Now, if you actually read the case, and I'm happy to go to it, the judge says something along the lines of, well, members of the jury, I think I can go further than common purpose and say this. So it's hardly a robust statement of a principle, but I have to acknowledge language of realisation is there. It wasn't quite yet parasitic accessorial liability, because that has liability for even unlikely foreseen crimes as well as likely. But it was, I have to acknowledge, language that's something along the lines of parasitic accessorial liability. The next stage in the development is Davis. I think I've already done that to death, and my learned friend did, where we had the language of contemplation. Can I just give you, for your lordship's note, Professors Wilson and Ormerod's commentary on Davis.
Yes.
It's at B882.
Thank you.
They say it was hardly illuminating, it was couched in the negative, etc., etc. Then we come to Wesley Smith, which was 1963. And this was treated by Lord Hutton in Powell as being the starting point for what he said was a strong line of authority. And I respectfully disagree with that. The line of authority is neither strong, and this isn't the starting point of it. But Wesley Smith is at 826. As you know, it was a bar brawl. Smith was outside throwing bricks at the pub. One of the men had remained in the pub, stabbed and killed the barman. All four were charged, and Smith was convicted of manslaughter. If you actually look at the decision, including the terms in which the judge directed the jury, it was a classic common purpose direction, where it was left for the jury to determine whether the use of the knife was within the common purpose, an attack on the bar and the barman, it being accepted that Smith knew that his co-accused had the knife, or whether it fell outside. And the Court of Appeal, in certainly not saying the judge hadn't gone far enough, simply said that it must have been clearly within the contemplation who knew, because Smith knew that P had a knife, that if the bartender did his duty to quell the disturbance and picked up the nightstick, anyone whom he knew had a knife in his possession might use it. By no stretch of the imagination can it be said that it was outside the scope of the concerted action. So we say Smith really is just a classic common purpose case. True it is the Court of Appeal used the language of contemplation, but they did not do so as a statement of principle that this was to be used henceforth to delineate the scope of a common purpose. It is a word that was used, but it was used in the course of upholding a common or garden, plain vanilla direction on common purpose.
Well, they did, but interestingly, if you look at the top of the same page, the judge, summing up that they were considering, whether it had led to a miscarriage or not, the judge made the point that a person who takes part in or intentionally encourages conduct will not necessarily share the exact guilt of the one who strikes the blow.
Yes.
His foresighted consequences will not necessarily be the same. Several persons, therefore, present at the death of a man may be guilty of different degrees of crime.
Yes.
One of murder, one of manslaughter. Only he who intended that unlawful and grievous bodily harm should be done is guilty of murder.
Yes.
That's the direction that they were considering.
Yes.
That has nothing to do with common purpose. That's a perfectly standard statement of accessory liability.
Yes, no, that's it. I think there are other passages that talk about common purpose, but picking up on Lord Hughes's point, yes, that is a far cry from providing a foundation for parasitic accessorial liability, albeit that's the summing up rather than the Court of Appeal's decision. What we say about it in our document, Wesley Smith, is that it was an interesting hybrid. It relied on what was contemplated might happen, or that was the language that was used, and whether that was beyond the traditional common purpose. But it also then returned, as I've said, to whether what occurred was within the scope of the agreed concerted action. The court is satisfied, quote, that anything which is in the ambit of the concerted arrangement is the responsibility of each party who chooses to enter into the criminal purpose. So we submit, and this is important for where I'm going on Powell and Daniels, that Wesley Smith is more of an expression of the common purpose rule, using what was contemplated simply as evidencing the common purpose, and not using contemplation as a delineation that is the common purpose by definition. However, we submit that the language of contemplation was adopted by subsequent cases, and as such, Wesley Smith plays a real role in the development of parasitic accessorial liability, as indeed we see in Powell and Daniels, albeit not at all, or certainly not significantly in Chan, which had its focus elsewhere. Coming to Anderson and Morris, which is one of the cases that your lordships, in granting us leave, specifically asked for submissions about. That was 1966, so 2 or 3 years after Wesley Smith. question of the scope of the agreed action we submit was again central to the decision in Anderson and Morris. Anderson and Morris were indicted for murder. They went to a flat in search of W. Anderson had a knife, which Morris denied knowing he had. And that's the difference between Wesley Smith. In Smith, there was knowledge of the weapon. In Anderson and Morris, there wasn't. And the deceased died from stab wounds pursuant to a fight in which Anderson was seen punching him with Morris standing at the deceased's back, not taking any part in the fight. Set out the jury direction, which I won't read out to save time. Anderson was convicted of murder, Morris of manslaughter. There was an appeal on the grounds of misdirection. Counsel for the Crown submitted that beyond established common purpose liability, there's a much wider principle, which you would put in this form, that if two or more persons engaged in an unlawful act, one suddenly develops an intention to kill, whereby death results, not only is he guilty of murder, but all those who have engaged in the unlawful act are guilty of manslaughter. That was not approved. In quashing the conviction, the Court of Appeal, presided over by the Lord Chief Justice, Lord Parker, said that where two persons embarked on joint enterprise, each was liable for the acts done in pursuance of the joint enterprise, including liability for unusual consequences if they arose from the agreed joint enterprise, but that if one of the adventurers went beyond what had been tacitly agreed, his co-adventurer was not liable for the consequences. And it was for the jury in every case to decide whether what was done was part of the joint enterprise or went beyond it. Accordingly, since the jury had been directed that in law they could or should convict M of manslaughter, even though he had no idea that Anderson had a knife, they were misdirected, and Morris's conviction, therefore, had to be quashed.
Now, it may be that in Anderson and Morris, the correct view of Morris's state of mind was that he simply wasn't rendering any assistance at all, in which case, end of question.
Yes.
But what do you say is the correct position if two people do, between them, expressly or tacitly, agree to attack another? The actual blows are struck by A and not by B, but who is there lending his support, perhaps calling out encouragement or whatever. There is at that stage, is there not, a common purpose to assault?
Yes, and also basic accessorial liability.
Quite.
If I'm encouraging my learned friend to hit somebody, then I'm aiding and abetting it.
Yep. And if the attacked man falls down, bangs his head on the pavement and dies, who is guilty of what?
They're both guilty of manslaughter.
Quite.
Because it's an unforeseen consequence of the assault.
Precisely so. Now suppose that he doesn't fall down and bang his head on the pavement, but unexpectedly, so far as B is concerned, but in the course of a fight which B is encouraging, A takes out a knife and stabs him. A is guilty of murder, assuming the necessary murderous intent.
Yes.
Yes?
Yes.
What about B?
In the course of a fight where a weapon is brought out whose use was not anticipated or even contemplated in any sense because he didn't know that it existed, he would be not guilty of murder.
What, of murder? No, but what about manslaughter?
Well, on read, he might be guilty of manslaughter.
Well, he would, wouldn't he, on any view?
Well,
unlawful act, objective likelihood of harm or risk of harm, result death. Why isn't that manslaughter?
because the act is outside the common...
Only if the act is so far outside the fight
Yes.
as to be, as it were,
A novice actus or...
yes, deus ex machina.
Yes, yes.
Yes, that's the right approach.
Yes.
Thank you very much.
We say Anderson and Morris and Smith are entirely consistent in that they are cases, as I've said, on common purpose, and whether what was done was inside or outside the common purpose. In Smith, it was inside because he knew he had a knife, and the joint enterprise, the common purpose in that case was an attack on the bar and barman. In Morris, he didn't know that there was a knife, and therefore he wasn't liable. Anderson and Morris is also notable because it uses the language of tacit agreement or tacit authorization, which was a new verbal formula in the cases. The decision, as we say in our document in Anderson and Morris, introduced for the first time the notion of authorisation of certain actions as providing the basis for and limit of liability. And tacit agreement was also introduced. Tacit or not, we focus on the word agreement as being important for our purposes, that one is having a meeting of minds, a coming together of minds as to a planned or contingent course of action. Common purpose liability doesn't require the parties to have voiced all the elements of the agreement, but there was leeway for attribution of liability. Tacit agreement was put to bed by the House of Lords in Powell and Daniels. Lord Hutton said foresight is a better
Just going back to Lord
formulation.
Hughes' question to you and your answer.
Yes.
In the way the court addressed that type of questions at page 120, isn't it, B586, where they deal with the argument addressed by Mr. Caulfield, as he then was, for the prosecution, where he'd argued, just above letter D, that it would be illogical if two people who formed a common design to do an unlawful act and death resulted by unforeseen consequence should be held liable as they are entitled with manslaughter, but if one of them, in the moment of passion, decided to kill, they'd be acquitted altogether. And the court's answer to that is, well, there isn't actually anything illogical in that. Could be considered as a matter of causation, which is quite an interesting point. There may well be an overwhelming supervening event of such a character that it will relegate into history matters which would otherwise be looked upon as causative factors. Now, obviously, when you're exercising judgment on that, or the jury is exercising judgment, there may be a line to be drawn. But it's, I think, from such seeds that fundamental departure later emerges, that one can recognise that even though the parties are embarking on a violent adventure, and if death results, the normal result would be liability for manslaughter all round, it is conceivable that you might have something so far removed from anything which could objectively have been likely to happen that they're out altogether. One you then come to read, and you'll find the court has rather strong remarks about the sort of things which are quite likely to happen in fights of this kind.
Yes.
There's a difficulty, isn't there, about treating the production of a weapon as necessarily amounting to the kind of overwhelming supervening event which relegates other things to history.
No, absolutely.
The boot
Yeah.
is a very common weapon and absolutely lethal.
Yes.
And if you're in a restaurant and somebody picks up a sharp knife from the table, well, that's there and around. Is there really a difference between that and pulling the knife out of his back pocket?
No, indeed, absolutely. It's an evident inferences from weaponry is discussed by Professor Ormerod, and it's just a matter of evidence rather than a bright line.
That's your suggestion.
Can we come to Reid? Because what I'd like to do is to look at Reid and then look at what my Lord Toulson said in his Glanville-Williams essay, because we respectfully suggest it is the correct analysis of Anderson and Morris and Wesley Smith, and not the analysis of the House of Lords in Powell. Reid is at B1742. It's page 112 of the law report. We've set it out in our foundation's note, if your lordships would prefer to look at it there. But it was a court of presided over by Lord Justice Lawton. Page 112, when two or more men go out together in joint possession of offensive weapons, such as revolvers and knives, and the circumstances are such as to justify an inference that the very least they intend to do with them is to use them to cause fear in another, there is, in our judgment, always a likelihood that in the excitement and tensions of the occasion, one of them will use his weapon in some way which will cause death or serious injury. If such injury was not intended by the others, they must be acquitted of murder. But having started out on an enterprise which envisaged some degree of violence, albeit nothing more than causing fright, they'll be guilty of manslaughter. So that was the reading of Wesley Smith and Anderson and Morris in Reid. And so can I come, please, to what my Lord Toulson said?
It's a fairly formidable team, that, isn't it? As has been pointed out, not only on the bench, but at the bar as well.
Yes, no, absolutely.
Right.
Yes, it was certainly a powerfully constituted set of advocates and also court. Coming to my Lord Toulson's writing, you have that electronically, and I would ask you to turn this up, please, at B2734.
Thank you. Yep.
Yes, the passage I'm going to ask you to look at is at 2741.
Yes. You know how to do that. You just go to view. Go to view.
Yes,
2741.
2741, yes, my Lord.
that's it.
And then rotate view. And then
Clockwise.
go, yes, that's right.
And then you need to probably zoom.
Yes.
Just to place it in context, at B2740, on the right-hand side of the page, Lord Toulson begins a discussion of Wesley Smith. Then over the page at 2741 electronic, 242 on the actual document, there's a case called Betty, then, which we've not looked at and I can pass over, then Anderson and Morris, and then counsel for Morris was Mr. Geoffrey Lane, later Lord Lane, etc. And the point I invite attention to, you'll find page 243 in the document, the final paragraph, and which I respectfully rely on. The position established by those cases may be summarised in this way. A person who took part in an attack on another or in an attempt to put him in fear of violence which resulted in death would ordinarily be guilty at least of manslaughter, whether or not the consequences were foreseen. He would be guilty of murder if, but only if, he had the mens rea for murder. However, he would not be guilty of any fatal offence if the conduct of the killer went altogether beyond anything which he could have foreseen. The jury in such a case would therefore have a choice of verdict: guilty of murder, guilty of manslaughter, or not guilty of any fatal offence. And then the well-known quotation from Glanbrook Williams: it seems that a common intent to threaten violence is equivalent to a common intent to use violence, for the one so easily leads to the other. And this approach was followed in Reed. And then, under 3, the current law, the law changed with the decisions of the Privy Council in Surrey in the House of Lords and Powell in English, and then a recitation of the principle that we are discussing. So I respectfully adopt and rely upon Lord Toulson's analysis of what the proper reading of Smith, Anderson and Morris, Reed is. That they are not cases about foresight at all, that they are cases about common purpose, and what they establish is that the secondary party needs an intent. It's right, I should point out, just for your Lordship's note as we're on it, the alternative interpretation in Powell and Daniels in English is in Lord Hutton's speech at page 19 of the law report. We've set it out and I won't read it. The court's focus at this stage, we say, i.e. in the historical chronology in the 1960s, was still on conventional notions of common purpose. And the Jogee Foundation document points out at 108 to 150 after Anderson and Morris. There are a number of cases which continue the traditional focus on the extent of common design or similar. We've looked at Reed. For your Lordship's note, in other cases, Lovesey, which my learned friend took you to, B1638. And there's also a case called Williams and Blackwood, which is not in the bundle, but is referenced in the Jogee Foundation submissions at 150. So we come then to Chan Wing Sui, and as I said in my synopsis at the beginning, and as my Lord Toulson observed, we say the law changed at this point, and changed in a radical and substantial way, but in an erroneous way. We say Chan Wing Sui was based on Johns, but Johns can't bear the weight, ought not to bear the weight that was placed in it. You've had the fact there were 3 appellants. It was a stabbing. And the prosecution's case was that the crimes alleged must have been contemplated by them as a possible occurrence in the course of their joint venture. The jury were directed, each appellant was guilty if proved to have contemplated that a knife might be used. They were each convicted on both charges and appealed, and the Court of Appeal upheld the judge's direction and dismissed their appeals. The decision we submit in Chan built upon the notion of tacit agreement and foresight, and set out the formulation of parasitic accessorial liability as it applies today. Now at paragraph 42 for those of your lordships and my lady following our written submission.
Thank you. Yes.
So it built upon the notion of tacit agreement and authorisation and set out the formulation. Namely, if S&P set out to commit one crime, say robbery, he's nonetheless liable for the greater crime, murder, if he contemplates or foresees that serious death or injury might result. The principle was set out by Sir Robin Cook, as he then was, at page 175 onwards. And then the key part of the judgment for our purpose is in considering the argument, and that's the argument put forth on the behalf of the appellant. The main proposition submitted for the appellants remained that an accused does at least have to be proved to have foreseen that if such a contingency eventuated, it was more probable than not that one of his companions would use a weapon with intent to kill or cause grievous bodily harm. So that sets the context of the argument.
That's the probable possible argument.
Yes, absolutely, yeah.
And foresight wasn't in question.
No.
It's interesting that although, as you say, from the point of view of appellate judgments, this, at least if you are right, might be regarded as a turning point.
Yeah.
Look at the judge's direction, the top of 175. Sorry, you've not got it in front of you.
No, don't worry.
It's page 18
Yeah.
of volume 1, or no doubt in various other places.
Yeah.
But the trial judge had got from somewhere
Yeah.
before Sir Robin Cook got at it,
No, absolutely. Yes.
precisely the proposition which Sir Robin then upholds.
Yes. No, absolutely. No, Sir Robin certainly didn't produce it out of thin air. What he does by reference to the judge's summing up is say, oh, well, the Australian authorities are authority for the way in which the judge directed the jury.
Yes, well, the Australian authorities may have something to do with it.
Yeah.
But
Yeah.
What is said in terms is there's little English authority, which is notable, given that in Powell and Daniels it was Smith and Anderson that was said to give rise to.
I mean, given the weight that's been placed on the Australian authorities, are you going to them at any stage, or are you going to content yourself with what's in your note?
I am going to come to John's, yes.
Right.
But the context of the decision in Chan of the board was, first of all, the judge's summing up, as your lordships pointed out, but also the proposition that was being advanced by counsel that it had to be probable and not possible. In other words, is foresight at all, whether probable foresight or possible foresight, is that good enough at all? That was just assumed. The correctness of the proposition was just assumed.
yeah.
That there is, and Sir Robin Cook goes on to say, considering that argument, should first be recalled that a person acting in concert with the primary offender may become a party to the crime, whether or not present at the time of its commission by activities variously described as aiding, abetting, counselling, inciting or procuring it. In the typical case in that class, the same or the same type of offence is actually intended by all the parties acting in concert. In view of the terms of the direction to the jury here, the Crown does not seek to support the present convictions on that ground. And then it's this. The case must depend rather on the wider principle whereby a secondary party is criminally liable for acts by the primary offender of a type which the former foresees but does not necessarily intend. That there is such a principle is not in doubt. No authority cited with respect. It turns on contemplation, or putting the same idea, in other words, authorisation, which may be express but is more usually implied. It meets the case of a crime foreseen as a possible incident of the common and lawful enterprise. The criminal culpability lies in participating in the venture with that foresight. And that is now cited as being the ideological, if you like, justification for why we have this form of liability. That's why you're guilty, because you can foresee it, but you go along anyway. And then he went on to say, in discussion of that principle that he said wasn't in doubt, page 176, in England it appears not to have been found necessary hitherto to analyse more elaborately the test which the jury have to apply. And then there was consideration of Commonwealth authorities, but principally in the context of whether it was a substantial risk, a probable consequence, something could well happen. That formed the context of the debate rather than, is there such a principle based on foresight at all? And it is for that reason, when you actually look at Chan, that we do say with respect, if Chan is the foundation for foresight, it's a pretty insubstantial foundation on proper analysis. The Jogee Foundations document at the end, as your lordships will have seen, has a comparative law section at the end, and it's paragraph, so it's in the bundle A212, that I won't turn it up, but I do invite your lordships, my lady's attention to it, because it is helpful and does make the point I've made, that the common law in Australia, and including in New South Wales, which I think where John's was, it has probable foresight of death as sufficient mens rea. As we say in our note at paragraph 45, although the decision in Chan accepted that some foreseen risks could be too remote to incur secondary liability, by ascribing liability for possible outcomes, it stands in what appeared or stood in what appeared to be conflict with the contemporaneous English cases on principal liability. Remember, Chan came at a time when the House of Lords was grappling with intent in the context of cases like Hancock and Shankland and Maloney and then the Court of Appeal in Nedrick. And so there were arguments after Chan Wing Sui that it couldn't stand and ought not to represent English law because of the approach to intention in Hancock and Shankland. And indeed, in a case called Barr, which you have at Electronic 1435 in 1988, Lord Justice Watkins at 1440. Lord Justice Watkins said there'd been a misdirection. And he said, where it's appropriate to direct a jury upon foreseeability of consequence, the jury must be told that evidence of such foreseeability does no more than assist the jury to determine whether a defendant had at the requisite time and intention either to kill or to do serious harm to the victim. In other words, foresight was simply evidence of intent rather than a sufficient mens rea in and of itself.
This isn't an accessory case, is it, or is it?
Yes, it was an accessory.
It is an accessory.
It was overruled. I'm mentioning it for the sake of historical completeness in the timeline. It was 1988. It was one of the earliest post-Chan decisions in the Court of Appeal here.
Thank you.
Lord Justice Watkins reverted to saying, no, foresight is simply evidence of intention on the part of the secondary party. But Barr was expressly overruled by the House of Lords in Powell.
In Powell. Yeah.
We point out in our foresight document that paragraph 49, we quote the Jogee submissions as being where the law had approached at this point or reached. Ultimately, paragraph 49, ultimately the courts moved towards the realisation that common purpose, the linchpin of the law for centuries, was less significant than a loose notion of foresight and continuation in the enterprise. The joint enterprise as an object must relate solely to the crime agreed upon and the part a defendant was to play in it. Liability for further crimes turns simply on acts that were foreseen. It's perhaps convenient to ask rhetorically at this point, why is this objectionable? We adopt the analysis of Professors Ormerod and Wilson in their paper at B885. Could we turn that up, please? I think it's the first time we've turned it up.
885.
Yes. It's the article starts at 880. particular, and it's under the heading murder liability for mere foresight of a possibility of another's intentional conduct. It's a long passage. Particularly in the case of murder, there's a significant injustice arising from the present state of the law founded on the joint enterprise approach. A conviction for being party to a joint enterprise may mean that the defendant suffers all the consequences of a murder conviction, including the offence label and the mandatory sentence, without necessarily having demonstrated any of the culpability or wrongdoing of the principal offender. Given that the wrong in murder is to kill with malice aforethought, to convict a secondary party of that crime, simply upon proof of his contemplation or foresight, this may be, sorry, let me start this again. Given that the wrong in murder is to kill with malice aforethought, to convict a secondary party of that crime, simply upon proof of his contemplation or foresight that this might be what his principal has in mind, takes considerable justification. And then he goes on, I'll invite your Lordship's attention to it. I won't read it in view of the time, but he goes on to...
You want us to read that further long paragraph beginning sinister?
Please.
Yep, very well, thank you.
It's Professor Sinister's
Yes.
justification.
Yep.
Thank you. Next in the timeline, although not in our note, but for your Lordship's note, the Chan Wing Sue principle was embedded into English law by Hyde, which was a kicking case, Court of Appeal presided over by Lord Lane. Your Lordships remember there was Wakely, which was a false start, as Sir John Smith pointed out in his note in the criminal law. But Slack and Hyde were direct applications of the Chan Wing Sue principle. We next come then to Hui Chi Ming, which was the second case that your Lordships asked for specific submissions on. The principal issue was whether a secondary party could be convicted of murder when the principal had only been convicted of manslaughter. You have the facts. This is the mistaken identity group attack in Hong Kong. In directing the jury, as we explained in our written note, the judge had told them, amongst other things, that the secondary party would be guilty of murder if he lent himself to a criminal enterprise knowing that a potentially lethal weapon was being carried, and it was used with an intent sufficient for murder. If they were sure beyond reasonable doubt that the secondary party had contemplated that in carrying out the common lawful purpose, one of his partners might use a lethal weapon with the intention of at least causing really serious harm, that was sufficient. Your Lordship's board held that the crux of the liability was what the secondary party foresaw, which needn't have coincided with what the principal foresaw. Hence, the board held that it was not a misdirection for the judge not to have directed the jury that the principal need have contemplated causing death or serious bodily harm. It was sufficient that he directed the jury that only the secondary party need have foreseen it as a possible occurrence. One point arising from that, as Lord Toulson pointed out this morning, this represents an uncoupling from John's. John's was a case where the principal and the secondary party had both contemplated. In that situation, it's easier to understand why contemplation can be treated as delineating the common purpose. If two people both foresee that something may happen in the course of what they are about to embark upon, I'm not saying it's necessarily correct to, but it's easier to see how one can treat contemplation as delineating the common purpose. But what Hui Chi Ming did and the Australian High Court then did in McAuliffe a few years later, is to say it's sufficient if the secondary party alone has foresight. So Hui Chi-ming represented a significant extension of the law so far as that point was concerned.
Is that right? I expect you're right, Mr. Knowles. You usually are, but
Thank you.
I'm looking at 129. And the judge's direction to the jury.
So would your Lordship just give me
Yes,
the
of
page?
course.
129. Oh, yes.
128, 129 are the judge's directions,
Yes.
and as in due course the board points out, you've got alternative bases of possible routes to conviction. A in paragraphs 8 and 9 taken together, which are standard accessorial intent, but also B, 10 and 11. 10, defendant would also be guilty if he lent himself to criminal enterprise knowing potential lethal weapon being carried, and in the event it is in fact used by one of his partners with an intent sufficient for murder.
Yes, that's how the judge directed the jury. That's right. I was in what I was saying about the uncoupling of the principal's state of mind. Sorry, the uncoupling of the secondary party state of mind from the principal. I had in mind what's said at page 134.
Thank you.
Johns v. the Queen is a leading case.
Yes.
I see.
Yes,
Yes, so we were taken to that this
Yes.
morning by Ms. Geary. Yeah.
Yeah, on the top of page 135.
Yes. Sorry, my lord, if we were...
Yes, all right, thank you. No, I've got it now, thank you.
So the one significance in Hui Chi-ming, if we're tracing the genesis of the principle, is it, whereas Johns, which we will come to, was a case where clearly what happened was in the contemplation of both parties because they discussed it on the way to the crime scene. Hui Chi-ming stands as authority for the proposition that it's enough if the secondary party alone foresees something, irrespective of what the principal may or may not foresee.
Providing the principal then does it.
Providing the principal then does it, yes, absolutely. The second significance of Hui Chi-ming is what is said towards the end of the discussion, because they go on to abusive process, but it's towards the end of the discussion on joint enterprise. Page 136, electronically, 53. Yep. The defendant's second point relies on Sir Robin Cook's use of the word authorisation. It's at letter C.
Yes.
Use of the word authorisation as a synonym for contemplation in the passage already cited from his judgment. Their lordships consider that Sir Robin used this word, and in that regard they don't differ from counsel, to emphasise the fact that mere foresight is not enough. The accessory, in order to be guilty, must have foreseen the relevant offence which the principal may commit as a possible incident of the common unlawful enterprise, and must, with such foresight, still have participated in the enterprise. The word authorisation explains what's meant by contemplation, but does not add a new ingredient. That this is so is manifest from Sir Robin's pithy conclusion to the passage cited. The criminal culpability lies in participating in the venture with that foresight. It's quite correct that mere foresight isn't enough. The secondary party obviously has to do something as part of the enterprise. He has to aid, abet, counsel, or procure. So that much is obviously right, that he needs to do more than have foresight, but this is authority and has been treated as authority for the proposition that foresight coupled with something is enough, rather than authorisation in contradistinction to foresight or contemplation. And we say, for the reasons I've outlined, that that's an error, because authorisation does carry as a matter of ordinary language, and ought to carry in the context we're talking about greater weight.
Yep.
Dr. Krebs has written a very helpful, in my submission, article, part of which discusses this principle. You have it at electronic B2666. And can I just invite attention to a brief passage, please, in that paper.
The passage at which page? 266?
Yeah, 2666.
Yep. Yep.
Yeah, sorry, just I think the paper is forthcoming, but it's yes. She discusses Lord Steyne. It's the middle of the page. Lord Steyne in Powell was particularly explicit that we need to look no further than what S contemplated to found liability, and so we have a quotation: "Foresight is a necessary and sufficient ground of the liability of accessories. That is how the law has been stated in two carefully reasoned decisions of the Privy Council, Chan and Hui Chi Ming." And then Dr. Krebs goes on to say, indeed, some passages in Chan lend support to Lord Steyne's proposition that foresight is a necessary and sufficient ground. And then a quotation from Sir Robin Cook in Chan. But then she goes on to say, however, an earlier passage indicates that Sir Robin Cook may here have been using the expression contemplation with a rather specific meaning. That there is a principle of joint enterprise is not in doubt. It turns on contemplation, passage that we've read. And then she says this: in this passage, contemplation is equated with authorization, a term that seems to require simply more than just foresight. Authorization implies approval, sanction, or endorsement of the acts and consequences foreseen. Arguably, the way that authorization is further linked, it meets the case of, with participating, suggests that the expression participation is here used as a shorthand for a participation that gives rise to an inference of approval. In continuing to participate, the defendant shows that he has authorised in the sense of approving or deciding to live with the consequences. In other words, he has endorsed the potential outcome of P's actions, if only to achieve some other goal. On such a reading, the very concept of participation would include an element of volition and foresight, although still a necessary ingredient, will no longer be sufficient to ground S's liability. And then the other case Lord Steyne cites in support is Hui Chi Ming. Lord Lowry delivered the advice with regard to an alleged misdirection concerning joint enterprise. He observed that the passages in subsequent cases which were aimed at rewording the joint enterprise principle as enunciated in Chan had often been misleading, and then so on. Just for your Lordship's note, can I invite you, either, when you're considering the submissions, to read on to page 2671. But we say that that is an alternative interpretation of what Sir Robin was saying in Chan, that authorisation, read in the sense that we submit it ought to be, would result in an elevation of the mens rea requirement that would better meet the justice of who should be convicted of murder and in what circumstances, because it would replace mere foresight with a degree of approval as being a necessary component. That is a less radical solution than the creation of an intent requirement, or the reinstatement, I should say, of an intent requirement. So then we come to Powell and Daniels and English. And as I've already indicated, in common with Lord Toulson, we say that Powell and Daniels, while building on Chan, did represent a new departure so far as English common law was concerned in incorporating the foresight test. Your Lordships have the facts of Powell and Daniels and English. The first certified question related to whether it was sufficient to found a conviction for murder for a secondary party to a killing to have realised that the primary party might kill with intent to do so, or must the secondary party have held such intention himself? And as I said earlier, the focus, and if one reads the arguments, the focus of the submissions were very much on a Maloney, Hancock and Shankland style approach, rather than a detailed peeling away of the history of joint enterprise in the way that we're doing here today. We should start, well, I wish to just look at, please, because I don't think we've done it yet, the speech of Lord Mustill.
Yeah.
Oh, now this is the one where we need to go to the secondary.
Yes, it's 13. Thank you. It's 137 in the soft bundle that was handed up this morning.
Yep.
So, Lord Gough presided, Lord Jauncey agreed with Lord Hutton, Lord Gough agreed with Lord Hutton, and Lord Mustill gave a short speech concurring in the outcome, namely the dismissal of the appeals in Powell and Daniels and the allowing of the appeal in Philip English's case. But in doing so, he indicated that he had prepared a speech which he didn't in the event deliver, which took a different analysis of the relevant principles. And it is unusually helpful, I think, to look at this, because I can draw limited support from it. He says at page 10, letter F, that his own reasoning, or let me start slightly higher up, several months before English's appeal had been allowed without reasons. And then he said that I felt and continue to feel that neither on the authorities nor in plain justice could it have been right to sustain English's convictions once it was properly conceded on behalf of the respondent that English, the appellant, might have been unaware that the knife ultimately used by Weddell was even in the latter's possession. So much is to my mind clear. Much less clear is the proper analysis of the law in a situation where the secondary party foresees that the principal offender may commit a more serious crime than the one which the two set out to commit, and nevertheless decides to go ahead with the plan. My own reasoning in summary was as follows. Throughout the modern history of the law on secondary criminal liability, at least of the type with which this appeal has been concerned, the responsibility of the secondary defendant has been founded on the participation in a joint enterprise of which the commission of the crime by the principal offender formed part. Any doubts on this score were set at rest by Anderson and Morris, by reference to which countless juries have been directed over the years. And that's my Lord Thomas's point. As it seemed to me, the House should not depart from this long-established principle without the strongest of reasons. The problem is to accommodate in the principle the foresight of the secondary party about what the main offender might do. Two aspects of this problem are simple. If S did not foresee what was actually done by P, he's not liable for it, since it could not have been part of any joint enterprise. This is what the court decided in Anderson and Morris. Conversely, if S did foresee P's acts, this would, as a matter of common sense, be relevant to the jury's decision on whether it formed part of a course of conduct to which S&P agreed, albeit often on the basis that the action would be taken if particular circumstances should arise. Intellectually, there are problems with the concept of a joint venture, but they don't detract from its general practical worth, which has proved itself over many years. In one particular situation, there is, however, a problem which this time-honoured solution can't solve, namely, where S foresees that P may go too far, sincerely wishes that he will not, and makes this plain to P, and yet goes ahead either because he hopes for the best or because P is an overbearing character or for some other reason. Many would say, and I agree, that the conduct of S is culpable, although usually at a lower level than the culpability of the principal who actually does the deed. Yet try as I might, I cannot accommodate this culpability within a concept of joint enterprise. How can a jury be directed at the same time that S is guilty only if he was a party to an express or tacit agreement to do the act in question, and that he is guilty if he not only disagreed with it, but made his disagreement perfectly clear to P? Are the two assertions incompatible? Are not the two assertions incompatible? At the same time, the culpability of S ought to be reflected in some form of criminal liability, attracting some degree of punishment. If one rejects, for the reason just given, the idea of forcing it within the existing notion of a joint venture, there remain only two alternatives. The first is to abandon that notion altogether and employ in all cases a test of foreseeability as the direct route to a verdict. The second is to retain the concept of a joint venture in all those cases, forming the great majority where on the facts it provides a complete test for whether S is or is not guilty of the crime which P actually committed. In the minority of cases where S ought to be guilty and yet can't be rationally treated as a party to an express or tacit agreement to commit the offence in question, his culpability can be established by a different route proposed by Sir Robin Cook, delivering the opinion of the Privy Council in Chan, namely that the culpability of S lies in his participation in the venture with foresight of the crime as a possible incident of the common unlawful enterprise. My Lords, I had, for my part, preferred the second of these alternatives. In other words, Lord Mustill is rejecting the foresight approach because I did not favour the abandonment of a doctrine which has for years worked adequately in practice and its replacement by something which I conceived to be new unless this step was strictly necessary. And I did not think it necessary, since the existing principles could be retained in combination for the exceptional case with the concept of wrongful participation in face of a known risk. This is indeed what I understood the law to be after Chan, Hui Chi Ming and McAuliffe v Queen. And then he said, given the importance of the topic, he prepared a speech. However, recognising that the remainder of your lordship see the matter differently, I prefer that the draft should be withdrawn. And then he goes on to explain why.
I do find a curiosity that having said that the culpability of S ought to be reflected in some form of criminal liability, he doesn't go on to say, which indeed it would be because he'd be guilty of manslaughter.
No, that can only be the that can be the only alternative.
But I mean, he would be guilty of manslaughter, wouldn't he?
Yes.
Well, he doesn't go on to say it because he's not addressing it. He's simply addressing the general moral case that he ought to be guilty of something. But in reality, that must be right.
Yes, although the majority quashed English's conviction, didn't substitute a manslaughter conviction. And indeed...
Yes, well, Powell and English produced, didn't it, as some mitigation of the severity of the rule which was being endorsed.
Yes.
The escape route
Of fundamental difference.
But not just a fundamental difference as referred to by Lord Parker in Anderson and Morris, but by fundamental difference constituted almost automatically by a difference of weapon,
yes.
A significant difference of weapon.
Yes.
For my own part, I never quite understood why if two people are going at the same man, one with a large bar of wood and the other with a knife, the difference between the two makes a difference.
Well,
for which English contended, but that was no doubt down to the advocacy of those engaged on behalf of English.
Well, without telling war stories, can I just say the factor in English was slightly different in that there'd been a joint assault on the officer with poles, which actually, as a matter of fact, hadn't produced much injury. Philip English was chased off by a police officer and was actually in the process of being arrested some 400 yards away. And Weddell's grappling with the deceased police officer, and it's at that point the stabbing took place. So there was actually a temporal difference. And what I think it was Mr. Justice Owen was the trial judge. Yes. He directed the jury effectively that they could carry over the prior intent to cause grievous bodily harm with the sticks to the assault with the knife, which on the prosecution's case took place about half a minute, I think, later. But certainly there was a difference in time. So that was the fact. It ought not to affect the principle, but that was the factual context.
Thank you.
In which the case was decided. So that was Lord Mustill. So he took a different view, or would have taken a different view in his speech had he delivered it. That he advocated the retention of the traditional common purpose approach, reserving for the exceptional case that he refers to, reserving foresight for the exceptional case. Then we have Lord Stane, and I think with respect to Lord Stane, we can pass over, I hope, his speech. Some of it we've referred to in Dr. Krebs's article.
We have Lord Hutton.
And then Lord Hutton. Then he sets out the background and the certified questions. And then Wesley Smith is the start of his analysis, and that's at electronic B3523, page 18 of the report.
Yep.
He says, and as I've made clear, I hope, we say this analysis is wrong, but this was his analysis with which the majority agreed. I consider there's a strong line of authority that where two parties embark on a joint enterprise to commit a crime and one party foresees that in the course of the enterprise the other may carry out with the requisite mens rea an act constituting another crime, the former is liable for that crime if committed by the latter in the course of the enterprise. This was decided by the Court of Appeal, constituted by 5 judges in Wesley Smith, and then he sets out the facts. The trial judge directed the jury, assuming that one of the 4 knifed the barman, assuming you're satisfied that it was done unlawfully in the course of an assault, was the appellant taking part in the general attack on the bar, directed in part at the barman, so as to make him a party to the general assault in some way upon the deceased barman. Manslaughter is unlawful killing without intent to kill or do grievous bodily harm. Anybody who's party to an attack which results in an unlawful killing is a party to the killing. So the direction certainly wasn't a direction about foresight. It was a direction about being party in a common purpose sort of way. In delivering the judgment to the Court of Appeal, Mr. Justice Slade referred to the direction of the trial judge that anybody who is a party to an attack which results in an unlawful killing is a party to the killing. He then stated, page 1205, in the view of this court, that's a wholly unexceptional direction upon the law, except, of course, where the act can be said to be wholly outside the subject matter of the concerted agreement. The terms agreement, confederacy, acting in concert, and conspiracy all presuppose an agreement express or by implication to achieve a common purpose. And so long as the act done is within the ambit of that common purpose, anyone who takes part in it, if it is an unlawful killing, is guilty of manslaughter. That does not mean that one cannot hypothesize a case in which there is an act which is wholly outside the scope of the agreement, in which case no doubt different considerations might apply, but the judge wasn't dealing with that case at all. The grounds of appeal in this case, although worded in different ways, really, as I understand them, amount to the same thing, that is, the use of a knife by Atkinson in this case was a departure, that is to say, assuming against Smith, as must be assumed in the light of the jury's verdict, that he was a party to some concerted action being taken against the barman. He certainly was not a party to the use upon the barman of a knife which resulted in the barman's death. It is significant, as I have shown by reading Smith's own statement, that he knew Atkinson carried a knife. Indeed, I think he knew that one of the other men carried a cutthroat razor. It must have been clearly within the contemplation of a man like Smith, who, to use one expression, had almost gone berserk himself, to have left the public house only to get bricks to tear up the joint, that if the bartender did his duty to quell the disturbance and picked up the nightstick, anyone whom he knew had a knife in his possession like Atkinson might use it on the barman as Atkinson did. By no stretch of the imagination, in the opinion of this court, can that be said to be outside the scope of the concerted action in this case. In a case of this kind, it's difficult to imagine what would have been outside the scope of the concerted action, possibly the use of a loaded revolver, the presence of which was unknown. But that's not this case, etc. The court is satisfied that anything which is in the ambit of the concerted arrangement is the responsibility of each party who chooses to enter into the criminal purpose. So that's the passage, and then this is the proposition that Lord Hutton derived from it. Therefore, I consider that in Smith, the Court of Appeal recognised that the secondary party will be guilty of unlawful killing committed by the primary party with a knife if he contemplates that the primary party may use such a weapon. In our respectful submission, that just reads too much into Smith. There was certainly no clearly articulated statement of principle to that effect in Smith. I have to accept the use of the word contemplation, which is italicised, is used, but we say it is an overstretch, if I may say so, with respect to Lord Hutton, for him to derive that proposition from that passage. Smith was simply a common purpose case, and the issue was the use of the knife within or without the common purpose, and the Court of Appeal's decision was to the effect that it was open to the jury to determine that it was within the scope of the common purpose, having regard to what the facts were, namely throwing bricks at the pub. Then Anderson and Morris, at page 3524, towards the bottom, is discussed. Anderson killed the victim, and the facts are set out. In delivering the judgment, Mr. Geoffrey Lane QC's principle was accepted, where two persons embark on a joint enterprise, each is liable for the acts done in pursuance of that joint enterprise, for that includes liability for unusual consequences if they arise from the execution of the agreed joint enterprise, but, and this is the crux of the matter, if one of the adventurers goes beyond what had been tacitly agreed as part of the common enterprise, his co-adventurer is not liable for the consequences of that unauthorised act. Yeah. Finally, he says it is for the jury in every case to decide whether what was done was part of the joint enterprise or went beyond it and was in fact an act unauthorised by that joint enterprise. And then there is a discussion, and he says there's a strict analysis, as Professor Smith pointed out in Wakely, a distinction between a party to a common enterprise contemplating in the course of an enterprise another party might use a gun or a knife, and a party tacitly agreeing that in the course of the enterprise another party may and a party tacitly agreeing that in the course of the enterprise another party may use such a weapon. Just pausing there, it said that's a matter of strict analysis. We say, actually, it's a matter of fundamental principle. There is a real difference.
And that's where Lord Mussel's speech becomes important.
Yes. Yes, I respectfully agree. In many cases, the distinction will in practice be of little importance because, as Lord Lane observed in Wakely, with reference to the use of a pickaxe handle, foreseeability that the pickaxe handle might be used as a weapon of violence was practically indistinguishable from a tacit agreement that the weapon should be used for that purpose. Pausing there, if that's a shared contemplation by two people, one can say, I have made this point, but this is a good factual place to make it again. If that's a shared foresight or contemplation by two people, one can see the logic behind the thinking, but if it's just foresight on behalf of one person, it's, I think, less of an accurate analysis. Nevertheless, it's possible that a case might arise where a party knows that another party to the common enterprise is carrying a deadly weapon and contemplates that he may use it in the course of the enterprise, but whilst making it clear to the other party that he's opposed to the weapon being used, nevertheless continues with the plan. In such a case, it would be unrealistic to say that if used, the weapon would be used with his tacit agreement. However, it's clear for a number of decisions, in addition to Wesley Smith, that as stated by the High Court of Australia in McAuliffe, in a judgment to which I'll return later, the scope of the common purpose is to be determined by what was contemplated by the parties sharing that purpose. Therefore, when two parties embark on a joint enterprise, one party will be liable for an act which he contemplates may be carried out by the other party in the course of the enterprise, even if he did not tacitly agree to that act. And that's where we see the jump and the elevation of what was a rule of evidence being turned by Lord Hutton in that passage into a rule of law, that before it was simply evidence of what the common purpose was. If they've contemplated it, it's open to a jury to conclude it was within what they'd agreed. And here we now have it based on McAuliffe, itself based on John's elevation into a rule of law. And this is where we say the tracks get jumped, as it were.
I understand. I notice you're halfway through here and you've got another quarter of an hour till...
Yes, in fact, there's quite a lot in the written notes because I deal with Udin and fundamental difference and Raman and Ganango a little bit, which I'm not proposing to do in my oral submissions.
No, I just...
Are you going to deal with, come at some point, right to the very end, what you say is the proper approach at common law, both in relation to murder and in relation to manslaughter?
Yes. Can I just finish, Powell and Daniels, because as my Lord Hugh said this morning, we do have to confront it for better or worse. The principle stated in Smith, and so Lord Hutton again comes back to Smith as being foundation, and so that's why it's important to look at Smith and look at what it really decided, because again we say it doesn't bear the weight or shouldn't bear the weight that was placed on it. The principle stated in Smith was applied by the Privy Council in Chan. Well, certainly Lord Cook didn't use Smith as the foundation for his principle. He looked elsewhere, as we've seen. Anyway, that's quoted, and then Hui Chi Ming is then cited in the passage I've already cited. In McAuliffe v. the Queen, the High Court of Australia has recently stated the test for determining whether a crime falls within the scope of a joint enterprise is now the subjective test of contemplation. Each of the parties to the arrangement or understanding is guilty of any other crime falling within the scope of the common purpose which is committed in carrying out that purpose. Initially, the test of what fell within the scope of the common purpose was determined objectively, so that liability was imposed for other crimes committed as a consequence of the commission of the crime, which was the primary object of the criminal venture, whether or not those other crimes were contemplated by the parties to that venture. However, in accordance with the emphasis which the law now places upon the actual state of mind, the test has become a subjective one, and the scope of the common purpose is to be determined by what was contemplated by the parties sharing that purpose. There is, therefore, a strong line of authority that participation in a joint criminal enterprise with foresight or contemplation of an act as a possible incident of that enterprise is sufficient to impose criminal liability for that act carried out by another participant in the enterprise.
Right.
And then discussion of Anderson and Morris. Yeah. And then at D, page 22, electronic B 3527, after a discussion of Anderson and Morris, I consider the judgment in Anderson was not intended to constitute a departure from the principle stated in Smith, and that the acceptance of Mr. Lane's test was regarded by the Court of Criminal Appeal as an alternative way of formulating the principle stated in Smith, although, as Professor Smith has pointed out, as a matter of strict analysis, a distinction can be drawn between the two tests.
Yeah.
And there's reliance on Lord Parker and Anderson and Morris at page 120 for a foresight-based test. So we say, and then they go on to address whether the law's been changed by Maloney and Hancock, which is how the case was argued, as I've said, and a rejection that those cases had anything to do with the case of a secondary party. So what we say on Powell and Daniels, with very great respect to the majority in that judgment, that Smith seems to be very much the cornerstone of the reasoning. The principle in Smith is referred to again and again, but we submit there is no principle in Smith, or certainly not the one which was said to exist. That is all I think I need to... that is all I wish to take you to. No doubt my learned friends will take you to other parts of Powell, but that's all I propose to take you to. So we set out in our note the fundamental difference principle, which was the other half of Powell and Daniels, but I needn't turn to that, I think, because that's not really an issue in our appeals. Then we deal with Rahman in the written note, and again, I don't think I need to...
Basically, say Rahman was an application of Powell and Daniels, although one or two passages at first sight might suggest otherwise.
Yes, no, that's absolutely right. In Rahman, what was said was, I thought he was just going to cause grievous bodily harm. He formed a sudden murderous intent, and therefore it's fundamentally different. And that was held by your lordships to not qualify as a fundamentally different. There are passages in Rahman which seem to suggest that what the secondary party needs to foresee is just an act and not the fact that there will be a stabbing with intent to cause grievous bodily harm or murder. But in ABCD, my Lord Hughes indicated that's not the proper reading of Rahman, and what the secondary party has to foresee is the act with the relevant mens rea for murder on behalf of the principal.
Which is,
Okay. When looking at the sort of departure between the difference between Smith and Anderson,
Yes.
it's quite interesting to look at the depth of the argument that was before the courts.
Yes.
Whereas very few cases seem to have been cited in Smith.
Yes. That is, I think, a point that Dr. Dyson makes
Yes.
in some of his writings and the Jogee team make in their submissions, that I think at least Smith was an extempore judgment. I can go back and check, but...
Well, it doesn't matter, but actually, whereas there seems to be agreement on what the law was in Morris and Anderson, Smith seems to not have gone into the old cases to the extent that Mr. Geoffrey Lane, as he then was, did.
Yes.
And therefore to use Smith as the to treat Morris and Anderson really as being a departure from Smith gets it the wrong way round.
I respectfully agree. Yes, I respectfully agree.
It looks as if it was an extempore judgment.
It was.
Yes, there's only one date.
Yes, that was my memory.
Yes, I think that's right.
And no Corad vault.
So, with an eye on the time... Yes, with an eye on the time, can I just invite attention to the remaining parts of our note? Yes, at 76, I come to Rahman, and I've explained what that case was about. All I would say in the subsequent cases that have applied Powell and Daniels, obviously it's been treated as stating the law and as being correctly decided. So
Not much choice except here.
No, absolutely. No, but in Rahman, the principle
Rahman, yes.
was taken as a given. And we discuss that Mendez we deal with at page 89 onwards, judgment of my Lord Toulson, an interesting discussion of the doctrinal or our view of the doctrinal underpinnings in terms of causation, which I don't think I need to dwell on. Mendez we deal with, 2011 Mendez we deal with at paragraph 92, and then Ganango, or Nango, paragraph 93, which was not actually decided on the basis of joint enterprise, as your lordships know. There were differing judgments, but it was decided on another basis. So coming to section D of our paper at page 40.
Yes.
What I've sought to do in the course of the afternoon is to try and identify the fault lines where we say the law took a wrong turning.
Yes.
And one of those ways that we say the law took a wrong turning is the misapplication or misinterpretation of authorisation. And we say it would be open to your lordships, in accordance with proper principles, to fashion a solution out of authorisation in the sense that I've explained it as requiring approval or something in that nature. That would fit within the context of the existing case law and would just involve a reinterpretation of what has been said in earlier cases, a more, in some sense, a more radical solution, but perhaps in some senses a more orthodox solution.
You don't want us to go back to Anderson and Morris.
In what?
Well, no, I mean, one is just to say that the law was as expressed in Anderson and Morris.
Yes.
May need a little refinement.
Yeah.
But you want to go, is that what you're saying?
No, I'm putting before your lordships, as it were, a palette of solutions. What I would submit is that...
But there's a huge difference between correcting where, as on your argument this afternoon, the law went wrong, and then you get back and put it on the right course, or you saying we should go back and put the law on the right course, but sort of tilt it quite substantially in a different direction.
I suppose it's where do you detect the fault? The principal fault is the elevation of the rule of foresight into a rule of law. And where we say the law should be returned to is to require require the jury to consider whether what was done was part of a common purpose or whether it was something outside a common purpose, in the sense of something which had been intended by both parties, perhaps perhaps conditionally, but nevertheless intended or agreed to by the parties as part of the common purpose.
So restating Anderson and Morris in slightly more,
Yes.
rather than sort of setting down a new route completely.
Yes.
But insofar as you are asking us to consider an alternative route, which involves a concept of authorisation,
Yes.
which is post Anderson and Morris.
Yes.
Can you put it in 2 or 3 sentences for us? What am I supposed to say to my jury if I'm applying the Knowles test?
This isn't your preferred solution, of course, is it?
No, it isn't.
No, it's not. I'm offering this as a compromise.
How far you've ended up, the final paragraph of your case, 108, sets out a formulation. I'd be interested to know to what extent you say that is a return to the law as it was before Chang's case and others, and to what extent you say, no, actually, this is branching off in a different and better direction. I mean, you've got a series of propositions there. 108, paragraph 1 is, I imagine, uncontentious.
Yes.
Paragraph 2 may be uncontentious. That's ordinary standard stuff. And then subparagraph 3, to what extent do you say that is actually a distillation of what can be found in the previous authorities? And to what extent do you say, well, that's actually different from the pre-Chang law?
It's different
In what respect?
by belief. That probably
So
represents...
that's the extension. So
that represents
Right.
a departure, because belief need not be intention, and on the analysis I've set forward, intention was always part of it.
2 points, one rather small point and one rather bigger point. If you're going down the route of 108.3a, would you accept that furtherance would be better than execution?
Yes.
Right. And the other point is this: you could, I suppose, say that whereas if you're right in your analysis of the pre-Chang authorities, they looked for a common purpose that certain things would be done, which it would include a conditional intent, i.e., that you are going further here by extending liability to a case where it wasn't necessarily part of the purpose it should be done, but there was a belief by one party, the defendant, that it would be done. You could say that in the light of Parliament's intervention with the creation of inchoate offences in 2007, including an inchoate offence consisting effectively of assistance or encouragement in the belief that it is such, that having been Parliament's intervention in that direction, if the inchoate offence is followed by a substantive offence, there would be a logic in the hitherto inchoate offender becoming liable for full offence.
Yes.
And that could provide a principled basis
Yes, indeed.
for saying that the substantive law should reflect the development, because effectively what the Serious Crimes Act did was to plug a gap.
Yeah.
Before the Serious Crimes Act, you had, among inchoate offences, attempt, and you had incitement. But the person who did an act, believing that it would help for the assistance of criminal acts, and one could think of all sorts of professional criminal examples, was not guilty of any offence at that stage. Now he is.
Yes.
And you could say that Parliament, having seen fit to extend inchoate liability in that direction, there is a logic in the substantive law of murder taking it forward. That wouldn't be the judges going off on a wing of their own,
No.
but following a principle laid down by Parliament.
I would respectfully agree.
Otherwise, I find it a bit difficult to see on what principled foundation belief would form secondary liability.
Yes. I think that I have shamelessly cribbed Professor Ormerod and Professor Wilson's. This is their formulation that we offer. But belief is the extension of the principle. But I respectfully agree that.
And we're coming to 4 o'clock, but the very important subject of manslaughter is now left, and it's 2 minutes past 4. And that's a very narrow formulation of manslaughter.
Yes.
There is an alternative, broader one, which Law Commission considered. You've referred to my talk on the Glanville-Williams series. I ended up canvassing that, and that could have a common law base in cases such as Church.
I do note the time, but can I answer my Lord Hughes's question now and perhaps reflect on it overnight? How to direct the jury? Well,
Don't do it off the cuff, Mr. No, it never works. Not in this sort of level. But if at some stage you can jot down a paragraph,
thank you.
it would help.
Yes, no, thank you. I'll reflect on this overnight. Thank you.
And direct the jury tomorrow morning.
Yes, thank you.
Good. Thank you very much indeed. We'll resume at 10:30 tomorrow. You have another half an hour.
Thank you.
Thank you very much indeed. Court's now adjourned.